just go ahead and take it. It's right. It's important to teach cases, right? Because it's the cases that actually define and interpret what the law means. Because you can look at a case and say, oh, okay, this is how they used it, so this is what it means. So it's important to use cases in law school, but the problem with that is sometimes we get into these silos, right? And you're like, well, where are they coming up with this stuff? Where, why did they, did they just pull this out of the air? Did they just pull this out of their butt? I mean, where is this stuff coming from? And 99.9% of the time, it's coming from some other case that wasn't the highlight case, right? It's kind of like playing a team sport. For instance, if you're playing basketball, you'll have the people who are known, that like Kobe Bryant was known because he was a really, really, really high scorer, right? He scored all the points, but he couldn't have done any of that without the other people on the field. Does that make sense? And so that Hodgkin's case was like one of the just as important teammates, but it didn't get any of the fanfare, which is why I had you read the Hodgkin's case. Good question. Good morning, Ms. Shelton. How are you?
Good morning, Professor Ledesma. I'm well. How are you?
Good, good, good. I know it sounds like I started class, but I haven't.
We're always chatting in this class. It's all good.
Chat. Lawyers like to hear themselves.
Exactly.
Chat. We're really saying nothing. It's been a rough weekend, so I'm
glad.
How
are you feeling? Did your fever break?
Yeah, and then I wound up having to go out of town, and so it was like it's been a hell of a week.
Oh my goodness. Well, you look great. That's all that matters.
Yeah, thank you. I appreciate that. I don't have earrings on, but that's okay.
That's okay.
We're here to talk about the law.
Exactly.
We are going to finish Void and Voidable today. We are going to get into what are we getting into today? We are getting into divorce. Oh my, have we gotten into marriage? Okay. The bar results came out. Do y'all know people? Yeah. Okay. All right. So
our 1L tutor, Josh Taylor, he passed his. He was on.
Yeah, Cassandra did too. Elaine.
Yeah,
it's. I saw a couple of names.
Yeah.
Okay. I don't know first name. So what's Cassandra's last name?
Escobarro, then Joshua Taylor. I think Elaine's last name is Robinson, maybe.
Yes. Okay. She was one of our barristers. Yes. Yeah. Okay. Nice.
I just know of a hand, like if they were tutors or something like that. Those are the only ones I know. Besides that, I'm not sure who else.
Excellent. Do y'all know anybody who didn't pass?
I know one person.
Did you reach out and let them know?
Not yet. I'm giving her some time.
Okay. All right. Well, don't forget to reach out. Let them know it's good, right? It's going to be fine. Yeah. All right. Well, they came out early though. Did y'all expect them to come out that early? I didn't expect them to come out that early. Did y'all know that they were coming out?
Yes, I saw a Twitter post. Some attorney, I think he sits on a bench somewhere in Texas, but he posted on Twitter that they were coming out. However, I was told that it came out before they actually gave the students their personal results though.
That's what I heard.
Yeah, so it's a little uproar because they're like, why haven't we gotten our results yet? And you guys just publicly put this out here for the whole world.
So what I understand, good morning, everybody. We're not talking, we're just doing, you come in class early, we're just chit-chatting. We're not talking about class. What I understand, and I don't know if this is the same problem or the same issue, Ms. Gilmore, as I'm looking over here because I'm letting people in. What I understand is that there was a technological glitch, and right, because usually when the students get their results, the law schools will also get results, right? And at some point after it had been publicized as a law school, I don't remember what it was that we got, but we didn't even get our complete thing, right? And it was like, wait, right? We're supposed to have more information, and then they sent out this thing that says, we're having some technical glitches. So, students didn't get individual reports. Law schools aren't getting individual reports. We're trying to work on it. So I don't know if it was the same glitch, but apparently there were some glitches happening where stuff was going out before other stuff went out. So yeah. But technology, right? Good morning, Miss Wisdom. Good morning, Mr.
Good morning, Professor Esma.
Nowalako. Good morning, Miss Murray, Miss Taylor. How are you guys doing?
We're doing okay.
I miss your faces. I miss your energy. I cannot wait to see you on Wednesday. I don't know. I might have to bring in some chocolate or something just to celebrate, to be back in this space. It's 9 o'clock, but people are still signing in. So, and I keep looking to the right because I'm letting people in the room, It's technology, so we're going to give people an opportunity to get in the room. I will thank you again for your grace. The Lord willing, I will be back with bells on come Wednesday. So that'd be amazing. Just letting people come in the room, We were just chatting about bar results. If you guys knew anybody who passed, if I knew anybody who didn't pass, make sure that you reach out to those people, let them know we love them. We haven't forgotten them, and we're happy to walk this walk with them. All right, that looks like I have 22. This is a critical mass, so we might go ahead and just get started. I will try to monitor my waiting room, but if you guys get a message from one of your colleagues, hey, I'm in the waiting room, can y'all let Ledesma know just to let me in, let me know. Because I'm going to share my screen in just a second so we can go ahead and get started with the PowerPoint. Good Monday morning. I hope everybody's doing well. Bar results came out way early, which I guess is a good thing for some, not a good thing for others. If you know somebody who passed, give them an extra high five, even if they weren't in your circle, right? Just give them a shout out. If you know somebody who didn't, let them know. We hadn't forgotten about them. We love them. And let's get it done together. Fantastic. We're going to finish Void and Voidable today. So hopefully you're ready, because I've got some hypotheticals. I've got some questions that I want to ask you guys to work through. There is one that I'm going to ask you to distinguish, where I'm going to give you 2 cases and I'm asking you to distinguish those cases. And so I've got a lot of exercises prepared. Admit, but we've got coverage. Y'all are going to see me throw a camera across the room in just a second.
What are you saying? Sorry.
Wait, here we go. There we go. I think.
Maybe stop.
By George, I think we got it. All right, let's get started. Sorry, Xavier, let me let you in. I've got 28, so I've got most of everybody. How's everybody doing Monday morning? Good. Miss Shelton is like, oh, it's good. Miss Shelton was like, it's a beautiful hair day. We're ready to go.
I got my hair done yesterday. Listen, I'm feeling myself.
Miss Valdez, Miss Murray. Miss Murray's like, I saw you, Sarah. That was funny. All right, Miss Davis, we've got smile. Look at Miss Jimenez. We've got smiles. We are ready to go. Miss Guy Foreman, let's do it. Let me share my screen. What I posted this morning, if you want to, if it's helpful, I posted the PowerPoint for Wednesday and today. This is another one of those PowerPoints that I just made. One PowerPoint. It's void and voidable. It has the material that we covered on Wednesday, and it has what we're going to go over today. So if that's more helpful than you taking notes, I don't know what is the most helpful for you guys, but if it's helpful to have the PowerPoint as we go through, it's posted on Blackboard. Okay. If it's just helpful to go over it afterward, then just leave it on Blackboard and you can always come back and get it. It's already posted. So let me share my screen and then let's get started. We're going to go to screen number 1. Perfect. Can everybody see my screen number 1? And on my screen number 1, what you should see is void and voidable marriages. Everybody see that? Give me a thumbs up if you see it. Perfect. All right. Move this camera one more time so that we're all looking in the same space. Perfect. Okay. This is where we started last week, and I'm gonna just kind of flow through them, right? So that we can pick up and so that there's an easy transition. You see that I've changed the PowerPoint. I've got class 16 and 17 last Wednesday and today. Let's go through it. We started class, oh, let me make sure I am video. Let's make sure I'm recording. Recording, yes, perfect, okay. Where we started last week was a review of the Black letter law. And this is my chart. I said, as you turn your weekly outlines into me, you might realize that changing your format may be more beneficial, or keeping the format, right? Here's an opportunity for you to decide what really works for you. I changed my outline format to this chart because visually charts work for me. Who gets the ring, premarital agreements, putative spouse, common law marriage. Yep. Questions about exam 2. We did that last week. We jumped into void marriages. We talked about incest. We defined incest to include not only the sexual relationship, right? It's not always about the salacious part of it, but really what we were trying to get to is a legal relationship between people wherein there is this level of intimacy. It's either an intimate partner, right? Like a marriage, or it's an intimate sexual relationship. For our purposes, we're looking at the marriage aspect. We talked about within the 3rd degree of consanguinity, gave you a chart, no problem. Then we went on to the 2nd category of void marriages, which is bigamy or polygamy. Some of you might decide that that's 3 separate categories: incest, bigamy, polygamy. That's fine. Some of you might decide that that's just 2 categories: incest and multiple marriages, which include bigamy, polygamy. Just whatever you intend, make sure you intend it. What does 3rd degree of consanguinity mean? I gave you a chart, so you would not have to wonder, remember, or guess. 1st degree of consanguinity, 2nd degree, 3rd degree. That is the general rule that you're going to be using. Whether it's my test, whether it's a UBE test, it's going to be within the 3rd degree of consanguinity, okay? We did a hypothetical. You guys knocked it out of the park. We looked at State v. Dodd, which was an older case, right? Because prior to the mid-90s, the law either said consanguinity, which is blood or adoption, or it said consanguinity and affinity, right? I gave you that case to read so that you can know that there was a time where those things were distinct and separate, but for your study purposes, it is together, right? It can't be by blood or adoption or marriage. That's the degree of consanguinity, right? So if you get a fact pattern that talks about people being adopted, like in Read the Adoption of M, we talked about that Woody Allen case, right? You're not going to be phased, you're not going to get confused, you're not going to get lost, because, you know, adoptive children are treated as biological children being blood children, that would fall under the area of consanguinity. All right. We went through the Woody Harrell case. Everybody took a shower after the case because it kind of made us all itch. And then we moved on with our day. We talked about Commonwealth v. Rahim. Again, this was one of those cases where the law talked about blood relatives, right? And he got off because it wasn't a blood relative. Again, I'm wanting you to be able to discern. So if you practice in Texas, once you've got your bar card, once you've knocked the UBE out of the park, you're going to know to look at Texas statutes to see, is this one of those that's consanguinity and affinity? Or is this one of those that's just consanguinity, right? If you practice in Georgia, or if you practice in Oklahoma, you're going to know to go to look to that specific state. But for the general purposes, consanguinity and affinity, right? Then I think we had questions about incest. I don't know, but before I go on, are there any questions about incest? Everybody feel good? We know the cases, we know the black letter rule, we know how to apply it. Nobody's going to be concerned or confused or thrown off by any of it, right? Right. Okay. So let's go into bigamy, polygamy. For the purposes of teaching, for the purposes of our class lectures, I'm looking at this as one category. I'm looking at it as multiple marriages, right? I'm looking at it as multiple marriages. I'm treating it as one category. The States v. Clement case, that is where the gentleman was married to a woman. Clements was married to Anderson. They were in, I believe, South Dakota. Anderson filed for divorce. Clements said, whatever, I don't care. I'm gonna go live my life. He found a woman in North Dakota that they went down to the marriage license office, filled out the certificate, got everything signed, got everything filed, got married that day. And then Clements was arrested, right? As a practitioner, as a student of the law, it may be kind of interesting to wonder, how did they pick this guy up for bigamy? Because nobody's walking around looking for people, right? Of all the things that I can arrest you on, right? Nobody's really walking around looking for bigamists. So he's like, what's the real story behind this case and how they caught up with this dude and actually filed charges against him for bigamy? I think inquiring minds wants to know, right? Some of those fun facts, but don't get lost in that in a test situation. Take what is given. Don't add anything to it. Just take what is given, right? So we know that he's married to Anderson. We know that he turns around and gets married to Björk, and he gets arrested for bigamy. He wants to argue it can't be bigamy because bigamy in South Dakota is ab initio. It is void on its face. And because it's void on its face, I can't be held responsible for violating a law that doesn't exist. I think me and Miss Guy Foreman, I believe it was Miss Guy Foreman, who talked about, well, you know, we might not like the argument, we might not agree with the argument, but it's a pretty good argument. The trial court bought it and dismissed the bigamy cases. The appellate court didn't buy it, right? And the appellate court said, look, this is the appellate court. The appellate court said, look, if we buy your argument, what's going to happen is that we're going to be in a situation to where the bigamy law is a legal impossibility, right? Which means there's no purpose to have the law. But the legislators created the law, and we don't sit as legislators. We're not here to make law or break law. As judges, we are here to interpret the law. So legal impossibility can never be a defense. And with that being said, the appellate court said, no, the law is valid because it hasn't been repealed. And when you try to enter into a marital relationship, we defined marital relationship a few cases ago. I believe we defined it with common law marriage. When you try to enter into a marital relationship with some person, when you know already that you are in a currently existing marital relationship, it's bigamy and it's a crime. And so what the appellate court did in this case was they reversed the dismissal of the trial court and they remanded it for further criminal proceedings. Bigamy, polygamy, any questions? Because it's pretty straightforward, right? Now, how would this be tested? Because this really seems pretty straightforward. How would this be tested? If there is a multiple marriage situation like bigamy, that would yield a putative spouse. Okay. And if I bother to give you a hypothetical, if the bar examiners bother to give you a hypothetical that includes a putative spouse, you know already that there's got to be something important about it, right? So this putative spouse is what? Trying to file, oh, let me let Mr. Jackson in. This putative spouse is trying to what? Trying to file a claim for wrongful death, or is trying to get spousal support, because a putative spouse can. Remember, we talked about what's the value of even having a putative spouse, right? Or trying to get child support, right? So if it is an essay, listen to what I said. I said an essay. I didn't say a true false. I didn't say a short answer. I didn't say a multiple choice. If it is an essay that involves a putative spouse, look for other causes of action that is of value for that putative spouse being recognized as a putative spouse, right? But like I said, you're probably going to have to go through maybe some common law questions. You're going to have to go through some multiple marriage questions, right? So just make sure that you're not superficially reading the essay prompt. Make sure that you're doing at least 2 or 3 reads. That's bigamy, polygamy. We had a question. Oh, wait, it's not going. There we go. We had a question last week, and it was a 2-part question. I was asked, am I teaching federal law or state law? And I said, well, for this part, right, for all of this marriage stuff, this is all state law, right? The first part of the class was federal law because we were talking about constitutional rights, individual rights, right? This part is state law. And then I think the question was, so is this Texas law? And I said, no. I'm a Texas lawyer who has practiced Texas law for 25 years. I am not teaching you Texas law because you're no longer taking the Texas bar, right? I'm teaching you general law for a general bar exam, the UBE, yeah? As I said that, and as I reflected on my notes from class, and as I looked back on some of the questions so that I could start preparing for class today, I did some research to see if I could find a federal case, right? Because generally, federal law, I mean, you got to have jurisdiction to get into federal court, right? Most of the time, that's not going to be the result of a domestic relations question. That's going to be a 10th Amendment state law question. But look at what I found. And I sent this to you guys because I was really pretty excited about it. It is a case, I believe it's from 2017, relatively recent. federal case about bigamy. And I said, oh, right, look at this. It's a really short case. It doesn't amount to much. We're going to spend 2 minutes on it. But here we go, one more time, confirming how important domestic relations is to the fabric of everything else that matters. Here is a question about bigamy and the right to exercise your religious freedoms, right? First Amendment case. If anybody read it, I think it's a 3 or 4 page case. There's not a lot to it. You see that the courts didn't use a lot of real estate. They didn't use a lot of space in doing a whole bunch of analysis, right? Because when it came to the bigamy, polygamy issue, basically the court says the Supreme Court of the United States in 1879 1879 decided this case for you guys, and we don't need to do it again. Good law, 1879. The Reynolds case, United States Supreme Court said, yes, for a state to say that you can only be married to one person at a time is absolutely, without a doubt, an interference with your fundamental right to marry. Boom. It may also be an interference of your right to exercise your religious beliefs if you are of a religion that believes in multiple marriages, right? Yes, it absolutely is. Do we stop our analysis there? Of course not, right? Of course not. We got to go to the next step, because usually it's right here. It's this next step where all bets are off, right? The next step being, now that I've identified a fundamental right, or now that I have identified a right for which I have guaranteed protections, right, an individual right, I have to look at the state's motivation for interfering in that right. If it's fundamental, right, if it's equal protection, we know that that interest must be compelling. 1879, the Reynolds case, as decided by the Supreme Court, said monogamy is a compelling state interest. And y'all can argue all day long about whatever you want to argue. Monogamy is a compelling state interest. And a law that is fashioned simply to prevent multiple marriages is narrowly tailored. And it is the least restrictive way to protect the interest of monogamy, right? So if you ever get into this mind melt, if you're ever talking to one of your colleagues, if you're ever talking to one of your study mates, and y'all start to fall down this rabbit hole of, well, hold on a second, right? It's First Amendment, hold on a second. Know that that matter has been resolved 1879. And if you want to argue against the state law for monogamy, you're going to have to be able to argue that monogamy is not a compelling state interest, or you're going to have to argue that the law that the state law that protects monogamy is not narrowly tailored, right? So I'm not saying that you won't get a fact scenario where you want to walk on the I don't want to say the dark side, but you want to go up against the grain and say, hey, I'm going to argue that this is a violation of a constitutional right, one of my individual rights. I'm saying go for it. Go for it. Be bold. But you know what you've got to attack, right? You've got to either attack the compelling interest argument that the state's going to make, or you've got to attack that is not narrowly tailored. And as of right now, 1879 says yes to both of those things. That's all we have to say about male v. or. Questions about bigamy, polygamy? Everybody feels good. Okay, let's move on. Let's add to our list of Black letter law, right? This is how my outline would look if I'm turning it in to Professor Ledesma on Friday. Your outline doesn't have to look like this, right? But this works for Ledesma. So I'm now adding to my list void marriages as it relates to incest, void marriages as it relates to bigamy and polygamy, right? One of the things that we're going to talk about very briefly, but it is in your outline and it's barely mentioned, but it is mentioned if you're using Barbary. And I'm not saying go Barbary. I'm not sponsoring Barbary because I'm sure Kaplan has the same thing. It's briefly mentioned in I can speak directly for Barbary. The Uniform Marriage and Dissolution Act, the UMDA. It's barely mentioned in your bar review outlines, but I want to point this to you because of this line right here. Let me annotate it. Let me get some color in here. What do I want to do? I want to, let's just stamp it. It's this right here. There's my attempt at drawing a heart. Don't do what I do. It's clearly very dangerous. Do y'all see my little ugly yellow heart that I wrote right there? Maybe if I put it over here. Well, no, it's over there. The Uniform Marriage and Divorce Act, right? Void marriages. You need to know this. That's why it's in my Black letter law chart. Okay. If the parties continue to cohabitate, God bless you. God bless you, Miss Wisdom. My goodness. If the parties continue to cohabitate after the impediment is removed, the marriage becomes valid. Say what? Right? What is the impediment in a void marriage? It's either consanguinity or affinity, or it's a multiple marriage, right? That's what makes that marriage void. That's what makes that marriage void on its face, right? If I want that marriage to be rehabilitated, I can remove the impediment, right? I'm in a polygamous relationship. Let me divorce one of these multiple people that I'm married to, and whichever marriage I don't divorce, whichever single marriage that remains, if we continue to cohabitate once the impediment, which is the multiple marriages, has been removed, then the marriage becomes valid. The marriage becomes valid. Ask me whatever you want to ask me where I may have just confused you. I'm waiting. I'm so wanting you to do this. I'm stopping the share.
I have a question.
Yes, Ms. Guy Foreman, please.
Yeah, so, okay, I can see how that applies with bigamy and maybe adoption, consanguinity, but how does that work with consanguinity when you are blood related?
It wouldn't, right? So I couldn't remove that impediment. Right? Good question, right? But so all impediments are not removable, but some of them are. And so what you need to know as it relates to that black letter law is if the impediment is removed and the parties continue to cohabitate, we've got a valid marriage now. So as you were looking through your facts, either for me or from the UBE, you want to make sure that there's no facts that talk about the impediment being removed, right? The adoption being dissolved if there was an adoption situation, or the multiple marriages being dissolved if it's a multiple marriage situation. And that doesn't mean that you're going to spend an extra half hour. That just means that you're going to read from the top of the hypothetical to the bottom of the hypothetical to make sure that you didn't overlook a fact that said that the impediment has been removed, right? Great question. Ms. McMillan.
I'm jumping ahead to
Please do.
voidable marriage.
Okay.
Would age be a impediment that could be removed?
Right. And so when we get to the other end of the voidable marriages, you're going to see again, and if you've looked at the PowerPoint already, you're going to see where I updated my chart again, right? And the black letter law for voidable marriages, you're going to see that once that impediment has been removed, if the parties continue to cohabitate, right? If they continue to, hey, oh, wow, woo, you were only 15, girl, I knew you had to be 21. And I really believed it, right? I really, and I'm learning, oh my God, we can't be married. This is an illegal marriage. Well, nobody files for an annulment, right? Everybody's good with it. We continue to cohabitate even after we've learned that there's a problem. For avoidable marriage, that's going to validate that marriage. Did that answer your question, Ms. McMillan? Yeah. Okay. So everybody good. We're getting ready to get into voidable. Don't jump ahead of me yet. Look, I'm asking about void marriages, incest, polygamy, black letter law. I am boring Ms. Schulten to tears, and so I'm going to move on. Yeah, everybody good? Okay. If something comes up, jump in. And because when I share my screen, I don't have the benefit of seeing all of you. If you've raised your hand and I didn't get it, I didn't realize you did it, just right, we're family. Jump in and say, hold on a second, I got a question, right? And we'll stop the train. All right, so let's go back to the screen share. And I don't want that one. I'd much rather have this one. And I'd much rather do it. Let's see. Is it gonna let me do it? No. All right, so there's two. Oh, you guys are seeing my screen that has all the different thumbnails on the left, right? Yeah, okay. So let's go here. Let's go share. And I will share screen number 1. All right, which means I need to move everybody over here. All right, fantastic. Screen number 1. Let's go. I'm asking it to resume, and let's see if it did. All right. Do you see annulments defined? No. Let me move you guys for a second. All right, let's do it this way. I'll move my camera in just a second. Share screen. Let's share screen 2. Ha. Now you see annulments. Nice. Let's go on this side. Let's go there. I'll come back to spatial repetition. Annulment. An annulment is a court order that says that your marriage is not valid. Well, isn't that a divorce? No. Two completely different things. An annulment says that your marriage is not valid, was not valid, and it returns you to the status that you were in before the marriage. We are married. I don't know that you had another spouse at the time. So technically it's void because it's a multiple marriage situation, right? We go on for 5 or 6 years, let's say 10 years. I never knew that you had another family in another state. I just had no idea. I now find out that you were married already, which makes our marriage void. What do? I can do two things. I can walk away, right? Because a void marriage is void on its face. I don't have to do anything else. It's just void, right? But after that amount of time, what I'm probably going to do is file for an annulment. Why would I file for an annulment? Because I want to get my 10 years back. Not that I'm going to actually get 10 years back, but I want to go back to the status that I was in, which was we had never been married. If I'm asked, have you ever been married? The answer is no, I've never been married. This was just a glitch in the system. This thing never happened, right? Why else might I file for an annulment? If we've had children, I want some support, right? And the annulment being a court order will allow me to address the issue of children, right? If there's some property or some retirement benefits and I'm the innocent spouse, you were the one lying to me, I want some of my property. I want 50% of that thing that we did, or I want that ranch, or I want that house, or I want that car, right? An annulment will allow me to address those matters. Does that make sense? If it is a void, VOID, incest, bigamy, polygamy, I don't have to do anything, which is why my chart for the black letter rule says an annulment is allowed if desired for property distribution, child-related matters, but it's not required, right? You can get it if you want to, but you don't have to. Does that make sense? But that's why people file for annulments, right? This marriage is void. I want it erased. I want to act as though it never happened. That's available for void and voidable marriages. That is not to be confused with a religious annulment, which is given for religious reasons. Let's not even go down that rabbit hole because you're not going to be tested on it. If it's something that you're curious about, we can have that conversation. But let's not get the two things mixed up for class purposes. Okay, I'm talking about legal annulments for void and voidable reasons. All right, let's talk about voidable marriages. What's a voidable marriage? There's your definition. It's a marriage that can be canceled at the option of one of the parties. Do you see the difference? It's presumed valid unless somebody does something. That is the exact opposite of a void marriage, which is presumed not valid, didn't exist, can't even be valid, even if you try. Voidable, think about capable, think about possible, right? A voidable marriage can be canceled, right? It's not automatically canceled. Somebody's got to do something. Yeah. All right. Well, let's talk about what that looks like. Houghton v. Kelly. Y'all know who Houghton v. Kelly is? Of course you do. right? Not a lot to say about it. Everybody knows the history. At the time that they got married in 1994, or at the time that a marriage was attempted in 1994, Aaliyah was 15, Robert was 27. They got married, they purported to get married in Illinois. At the time, the minimum age of marriage was 18. This is a voidable marriage. Voidable. What are you saying, Ledesma? What I'm saying is, had they continued to live together post the age of majority, once Aaliyah turned 18, which was in fact the legal age to marry in Chicago, had they continued to live together post the age of 18, they would have validated that marriage, right? Because Kelly knows she's 15, she knows she's 15. That's cool. What, right? What's the song? Age ain't nothing but a number, right? And we're gonna just keep doing what we do, and life is gonna be good because this is what we intended to do. I am now 18, right? And the marriage is good. Does that make sense? What happened? What happened was Aaliyah's parents, on her behalf, because she was a minor, she couldn't file a lawsuit. She's a minor, right? So Aaliyah's parents, on her behalf, filed the petition for annulment. Neither of the parents agreed with their minor child getting married before the age of majority, right? She doesn't have the legal capacity because she is a minor, right? And so the marriage was annulled. Real simple, right? I mean, there ain't nothing simple about it, because there's some, right, there's a whole bunch of stuff going on where birth certificates were fraudulently changed and all of these other things, and people were paid to look the other way and all of that stuff. That's not, while it's salacious and very interesting, the fact is she was under the age and her parents did not consent. So her parents had the legal authority to come in and file the annulment. So it was as if the marriage never happened. Any questions? No? All right, let's talk about Kirkpatrick v. District Court. Kirkpatrick v. District Court. Someone distinguished Kirkpatrick from Houghton, because we've got similar situations. We've got a 15-year-old girl, or 16, who wants to marry a 48-year-old guitar teacher, right? Different outcomes. In the Houghton Kelly case, the court said, we are happy to sign that annulment. We can't sign that one fast enough. And of course it's sealed, right? I was right. You can get the marriage license, but the actual lawsuit is sealed. So I couldn't actually get any of the marital documents or the dissolution, the annulment documents. But so we've got Aaliyah's non-marriage being annulled. We got Kirkpatrick's marriage being affirmed. We've got relatively the same laws, right? In New Mexico, you couldn't marry under the age of 16. She was 15. So she, mom, and the 48-year-old guitar teacher go to Vegas where she can get married. But you've got same age, young girl, marrying a grown man. One is annulled, one is affirmed. Somebody want to distinguish it for me?
Is it because one of her parents consented?
It's because one of her parents consented. It's because one of her parents consented. But hold on a second. The parent who didn't consent, who didn't agree, who filed a writ of habeas corpus, oh no, not habeas corpus, a writ of mandamus, so that the case could be heard so that the order that emancipated the child or the order that allowed the child to get married would be vacated, doesn't he as a parent have some constitutional rights? Didn't we talk about this? We talked about this already, right? Doesn't he have individual rights as it relates to his 15-year-old daughter?
The court authorization replaces that.
The court authorization replaces his rights. Well, we know that in order for a state court to interfere with a fundamental right, there must be what? A compelling interest that's narrowly tailored, right? What's the compelling interest?
Well, they were talking about how the daughter's interest in marriage and coupled with the mother's interest in the well-being of the daughter was outweighing the father's interest about her legal age.
Look at this. What Kirkpatrick did was it identified the limit of a parent's fundamental right to their child, right? It defined the limit. Let's go through it. Here we go. A little bit of facts. Y'all know the facts. Mom and dad married. Mom and dad had a kid. Mom and dad divorced. Mom and dad got joint legal and physical custody. We'll talk more about that when we get to custody. They were in California. Mom and daughter moved from California to New Mexico. Mom and daughter's 15, who's taking guitar lessons from a 48-year-old man. Daughter announces, I'm going to marry my guitar teacher. This mom said, well, hell, let's go to Vegas. let's all get in the car and let's take a road trip. So they all went to Vegas. Mom, following Vegas law, because Nevada law allowed a minor to get married with the consent of one parent, right? Very similar to Texas law, dependent upon who has the legal decision-making rights, right? Because in Texas, if you are the parent with the legal decision-making rights, you have the right to decide if your kid gets married before 18. You have the right to decide if your kid joins the military before they're 18, right? If you share those legal rights jointly, then both parents have to agree. But again, this is in Texas. We're in Nevada. Nevada says all we need is one parent. So mom goes down, mom files the petition for the court to grant permission for the minor child to get married to the man who's 3 times her age. I'm sorry, I'm stuck on that. Let me move myself from that. Okay, let me move myself from that. The affidavit attached to the petition, mom said, I agree. The judge found good cause to let this 15-year-old get married to the 48-year-old. I'm sure some of that had to be the testimony of the mother in the affidavit that said, I've never seen 2 people more made for each other. I don't know why that didn't result in a CPS referral, but let me get out of the facts of the case, because I'm telling you guys, don't get lost in it, right? Don't get lost in it. So the district court found good cause, signed the order that the child could get married. They got the marriage license. They did the marriage certificate. They got married. Boom, it's done. Dad finds out. Dad goes to New Mexico and files an ex parte restraining order. Based upon the facts probably that dad gave, the New Mexico couldn't sign that restraining order fast enough, right? Because any reasonable person is like, what the hell, right? Not only are we going to sign this restraining order, we're getting ready to give you temporary emergency physical and legal custody of this child. Go get her. Go get her, right? When dad tried to present the New Mexico order to Vegas, Vegas said, we'll give you a writ of mandamus based upon these circumstances, but we're only going to do it with a limited bit of leeway. So within 4 days, you guys have got to come back to court. And we need to figure out what's going on. Now, the daughter didn't show up, but the daughter's attorney did and said, Dad has no standing. Dad has no standing. She's emancipated. She's married. And then Dad said, well, hold on a second. Nevada has violated my constitutional rights. They violated my Meyer v. Nebraska 1923 right as a parent to be able to make critical decisions for their child. My decision would have been, daughter can't marry this 48-year-old guy, right? Court said, maybe. However, there's nothing that says both parents have to agree. Dad said, okay, well, if you're going to trample all over my fundamental rights to be able to make critical decisions for my minor child, you shouldn't be able to, walk all over my due process rights, because I didn't even get notice of this thing. I didn't get an opportunity at this court hearing to argue why this isn't in the child's best interest. You violated my procedural due process rights. Court said, maybe, but we had one parent here, and the one parent agreed, and there's nothing in the law or in the interpretation of the individual right clauses of the 14th Amendment that require both parents to be heard. So you may not have had an opportunity to be heard, but mom had an opportunity to be heard, and mom was heard, and that's the case. Questions? Thoughts? Ms. Uke, your face is saying a whole bunch of things, but your mouth isn't saying anything.
I was thinking of statutory rape. Well, I can presume that he hasn't had carnal knowledge of the girl. But how does statutory rape come in here in this case?
Say it again.
Statutory rape, how does it come in?
I don't know what the statutory rape clause is for Nevada, right? I don't even know if Nevada had a statutory rape clause. So that's a great question, right? Why are these things in civil court and not in criminal court? What the hell is happening? I mean, I'll take you back to in re adoption M. Statutory rape, molestation, sexual assault, right? I don't know. Great questions to ask. Right? And as lawyers, as justice advocates, as protectors of society, I think those are great questions, and those are questions that you should ask. In a test situation, don't let your mind go there, right? But no, from you have a responsibility once you get that JD and once you get that bar card to protect society. You have a heightened responsibility to be aware and identify injustices, right? You have a heightened responsibility to do something about the things that you see that are obviously critically gone awry. I think it's a great question. What about the statutory rape? I don't know. Anybody else? Right? So that would have been a situation where, right, that voidable marriage, right? The voidable marriage would have had to have been contested in the absence of a contest. Do you see what I said, right? My daughter's only 15. You cannot legally marry her. Here is a petition for annulment. That happened in the Aaliyah case, because Aaliyah said, get me out of this. And I don't ever want to see this dude again. Mama said, get her out of this. Dad said, get her out of this. They got her out of it, right? So there was no opposition to the contest of the marriage. Does that make sense? Everybody was on the same page. In the Kirkpatrick case, Dad said, get her out of this. But daughter said, oh, no, I'm good. I found my soulmate. Mom said, no, she's good. She found her soulmate. And we've got a court who agrees. Now, could the court have said no? I don't care what the mama think. I don't care what the daughter think. Deputy, put this 48 years, of course, right? Because as you will learn when it comes to children and judicial decisions, the standard is always best interest of the child. Best interest of the child, always best interest of the child. So the Nevada court did not have to find good cause to allow this 15-year-old to marry this 48-year-old. The Nevada court could have said, the buck stops right here, right? But they didn't. So we get to study the case. Yeah, any questions? That's age. Voidable, if someone had contested it without opposition, right? Yeah. All right, very good. And I said reconcile Hutchins v. and Kirkpatrick. We just did it. Let's talk about capacity and competency. Capacity and competency, I'm treating that as one category. If you want to take it apart so that there are now 4 categories of avoidable marriages: age, capacity, competency, Freud, you can do it that way. That's fine. You're not going to lose any points. You're not going to get any points, right? It's fine. I'm treating it as age, capacity, and competency together, and then Freud. Okay. So quickly, let's talk about Spears v. Ferdeline. Not a lot to talk about, right? Spears is in the middle of a mental health break, I think is what was going on with her at that time. She went off to Vegas with one of her choreographers. They got married. And the annulment was based upon her lack of capacity to enter into that agreement. It was based upon her mental health status, right? Short, sweet, not a lot to add to it, right? Short, sweet, not a lot to add to it, right? We're gonna get a little bit further in when we get to the next case, but Spears, Ferdeline, that's an example of mental health capacity. And I'm acting like I know Britney Spears. I don't. And I'm acting like I know that case. I don't, right? So I don't know if the annulment was based upon mental health incapacity or if it was based on drug and alcohol substance abuse. I don't know. But either of those would qualify as a lack of capacity, right? Here becomes the problem. I get drunk or high off my mind, or from a mental health perspective, I'm not in my healthiest space and I'm not really making good decisions. And that can happen. If it hadn't happened to you, stay in this profession, it will happen to you. It's stress, right? It's stress. And if you have any other underlying factor like anxiety or depression, or if you have any of that stuff, right, it's stress. If that's the situation and I get married, and then once I come to my senses, once I sober up, or once I get on medication or go to therapy or whatever it is that I need to do to get back settled, once I get back settled and I continue to cohabitate with this person, I validated that marriage. Does that make sense? right? That is the voidable's equivalent of the void marriage, where if after the impediment has been removed, we continue to cohabitate, then I validated the marriage, even though technically a void marriage doesn't exist. If I have confused you, if I have lost you, if I have spoken too quickly, stop me. Okay, all right. So when Spears came back from Vegas, and once she got settled, whatever it needed to be to get her settled, once she got settled, if they continued to live together, there would be an argument that the marriage should be validated, right? Well, how do you make that choice? Totality of the circumstances. Totality of the circumstances. Here's a perfect case of totality of the circumstances, but this one is not going to capacity. This one is going to ability, right? Think about old school marriage doctrine. We've talked about it all along the way. We've talked about it with Roe v. Wade and having kids. We've talked about it, Planned Parenthood v. Casey, telling the husband, right? Think about this whole idea of marriage. We talked about it in Loving v. Virginia, right? We talked about it in our first case, Griswold v. Connecticut with birth control. Old school foundation for getting married. Why the heck do people get married? To have kids. Now that I understand that we've moved away from that, but right, all of this is still very much an old school foundation, right? So if you don't have the ability, if you don't have the mental requisite, you can get out of it, right? Mental health, drugs, alcohol, I'm not thinking straight. If I don't have the ability to procreate, I'm impotent. Or the willingness to procreate, that is still a ground for an annulment. Okay, old school. That's the Jonda v. Jonda case. Anyone watch 90 Day Fiance? I don't know if this is the first season or if this was just the first time I found it, but God, I don't even remember the people's names now, but somebody from Sandusky, Ohio or something, the woman, the guy, whatever. Yeah, let me not go into it. This is that case though. This is not that case, but this is a case that's very similar. Jonda v. Jonda, what are the facts? Antoinette wants an annulment. Why does she want an annulment? Because she is dating a guy from Czech Republic, right? And it sounds like one of those 90-day fiance situations where you come here, you know, I see you online, I dig you, you dig me, or at least I say you dig me, you say you dig me. Life is good. Why don't you come over and we can have a great time? Because Americans very egotistically believe that everybody wants to come to America, right? It's please forgive us, because it is one of the character traits that is not so great, but everybody thinks everybody's trying to come to America. So Antoinette is hanging with Jerry. Jerry's like, cool, I'll come to America. If he came on a visa, if he came on a marital visa, right, you got 90 days, et cetera, et cetera, et cetera. So they have a really quick courtship and then they get married. They go camping for their honeymoon. They don't sleep together. They come back from the honeymoon. They don't sleep together. Antoinette says, well, I recognize we got some different cultural stuff going on. So, right, at least hats off to the recognition that everybody doesn't think like Americans think, because we think that too, which is ridiculous, but we do. We think everybody's supposed to think the way that we do and like what we do and whatever. And so she's like, I'm gonna chill with it. I'm gonna chill with it. We're gonna ease into this thing. They move into their place. They're sleeping in separate bedrooms. Eventually she has a conversation with him and says, we're married. We're married. Can a sister get a little time? And he says something not so kind about her appearance. Okay. And she says, I mean, I want to hang out with Antoinette because Antoinette's got that, she's got the attitude of a soldier, right? She's a warrior. She's like, ain't no sweat off my nose. Not a problem, baby. If that's all it takes, boof. She dropped 65 pounds, right? And she says, how about now? Right. And he's like, yeah. Took her almost 2 years. But she came to the conclusion that he was never interested in her. She came to the conclusion that this was really a situation about you getting to America and you getting a green card and you really had no love for me at all, right? So she files an annulment based upon the ground of a lack of, God, my brain can't think of it, consummation. We hadn't consummated. We've been married for almost 2 years and this marriage hadn't been consummated. So I'm going to appeal. The trial court granted the annulment. Jury said, Skr! What happens in an annulment? The marriage is erased. It is as though it never happened. He loses his green card, right? Because there's no marriage that ties him to the United States citizenship, right? So he's going to have to go back to the Czech Republic. He said, no, right? I'm going to appeal. And he did. You'll read the appellate court kind of going through some ideas, Some of the justices on the appellate court said, this sounds like fraud, right? It really sounds like a case of fraud. However, and fraud is our last category. However, fraud is so freaking hard to prove, and courts don't like the idea of fraud, right? And so they found another reason to support the annulment. And the other reason was what? They didn't consummate the relationship, right? They're not procreating. There's no babies. This marriage is not producing any of the fruits that are so ingrained in our understanding and our culture of what that marriage is supposed to produce. And so they upheld the annulment based upon the lack of consummation. But if you read the analysis, the court said, this is really hard, right? If you look to the right of the screen right here, where it says the appellate court of fraud was perpetrated, right? We recognize that it was a fraud. We're not going to grant it on the grounds of fraud. We'll grant it on the grounds of a lack of consummation. But even on the grounds of a lack of consummation, this one is a really, really, really hard case. Why? Because of the length of the cohabitation, right? At what point did she acquiesce? At what point did she say, okay, you tricked me. Okay, you got me. Okay, you don't want to have sex with me. Okay, you don't want to have kids with me. Okay, you frauded me, right? At what point did she recognize it and acquiesce and just say, then I guess that's how it's going to be. Right. And that's what I'm saying when you're trying to determine whether or not the voidability is valid, you got to look at all of the circumstances, right? Now, the fact that she gave some time because of cultural differences, and then the fact that she gave some time to lose 65 pounds, and then the fact that she gave some time. So the court gave her the benefit of the doubt and said, well, it's not like you were just sitting there doing nothing for almost 2 years, right? You were really trying to find rational reasons why not to end this marriage. And therefore, we got an annulment. Yeah? Questions? Mental health, substance abuse, right? Or the lack or unwillingness to procreate. Because there was nothing in this fact pattern that indicated that Jerry was impotent, right? Nothing in this fact pattern. He just wasn't willing. Okay? All right. Fraud. Told you we were going to wrap it up today. Salacious, interesting. Ooh, this sounds like a real housewife. Or real housewife, husband, whatever. Husband wants an annulment. Husband and wife had sex once. Okay. At the time that the husband and wife of this case, Blair and Blair, at the time that Blair and Blair had sex one time, she was married to another dude, Mr. Farah, and she was having a long-term sexual relationship with another dude. Okay. The wife gave birth to a son. Now, they weren't married at the time. She's still married to Farah. She's still actively engaging in sexual relationships with another person. And she had slept with Blair once. Okay. But she comes up pregnant. She gives birth to a son. She's still married to Farah, right? Because she's still married to Farah, Farah would have been the presumed father. We'll talk about that when we get to paternity, right? He would have been the presumed father. She's doing this guy over here regularly, which means he's probably the father. However, it only takes once. We all know it only takes once. She had sex the one time with Blair, right? But anyway, let's move on. She gives birth. Blair doesn't have anything else to do with her. 2 years later, when the baby's 2, she says, hey, Blair, you know what? I never told you. You're the baby's dad. And I scratched my head, honestly, but that's probably the same thing he did, right? He's like, okay, so what are we going to do now? This is what we're going to do. The wife is going to separate from her husband. She's going to resume sexual relationships with Blair. I'm not real sure about oh boy over here because the facts don't tell us anything about what's happening with the guy that she's having sex with regularly, right? And so once she divorces Farah, she reconnects with Blair. They become a happy family. Blair and Blair now marry. Mr. Blair adopts this child as his child, if it's not his child anyway. She has another child with, I assume, Blair. Blair adopts that child too. Miss Gilmore, I'm thinking the same thing, right? Let's not get lost in it, but it's not lost on us that the facts tell us that he adopts the second child as well. The second child is the child that's born from their marriage. Why is he adopting that child?
Yeah, I'm like, when the baby get here, sign the birth certificate and go on about your life.
And because you're married, you would be the presumed father. But, right, as a lawyer, your mind is going to be like, okay, y'all aren't giving me everything, right? As a student preparing for a test, whether it's Ledesma's test or the UBE, you're going to say, I see you, but you're not going to spend a lot of time in it, right? Right? I'm not going to spend a lot of time in it. So they're married for 21 years. 21 years. So the baby that she said was his when she was married to Farah is now at least 23, right? And then the second child that they had soon after has got to be 21, 20, right? So 21 years they're married. She files for divorce. We don't know why. Don't add anything to the fact scenario. She files for divorce, right? He says, bet, I'm gonna file an answer and I'm gonna file a petition for annulment because I want these last 21 years erased. I'm filing an annulment. An annulment erases it. An annulment takes me back to the status before we got married, as though the marriage never happened, right? So he's in his feelings, but I might be in my feelings too, right? That's not a judgment, but he files for an annulment. And this is the reason for the annulment. He says that the only reason he married her 21 years ago was because she told him that the child that she had was his child. And but for her saying that was his kid, he never would have thought twice about it. So what he's saying is that he was fraudulently induced into this marriage. This is why courts don't like to find for fraud. Here's the test. It takes forever. There's lots of elements that have to be established. And this is a conjunctive rule, which means all of these elements are required. And I see that we're out of time. So rule number one, he believed that the child was his, or element number one, he believed that the child was his because she told him, she represented to him that the child was his. She had to know that the child was not his when she told him. He had to rely to his detriment on the lie that the child was his. The wife had to intend that that lie was going to get him to rely and do what it was she wanted, which was to get married. He has to show that there were actual damages. He has to show that he had clean hands. He didn't know that the child wasn't actually his. He didn't know and should not have known that the child was actually his, right? He would have to establish all of those things to win fraud, right? What did the court find? The court said, we're not giving you an annulment. We will grant you divorce. Part of the problem is y'all lived together for 21 years. 21 years. This is insane, right? And the bigger part, which is the problem with fraud always, is he's saying that the only reason he married her was because she said that the child was his, when in fact he had said he loved her and he would have married her anyway. She testified that he loved her so much that he would have done anything for her, right? So all of those negate that the only reason that he married her was because of the lie. And here's the biggest problem. It was never established that the kid wasn't his. So we don't even know if there was a lie. Here's another thing. It was never established that she knew that the kid wasn't his. So we don't know if the kid wasn't his or not. We don't know if she knew that the kid wasn't his or not. Right. So none of the foundational things that he needed to show that he got tricked by her, manipulated by her, was evident, right? So they denied the annulment, granted the divorce, and the people went on about their merry way. It's already up in Blackboard. I'm just flipping to this to show you I have now added to my Black letter law review. I now have age, I now have capacity and competence, and I have fraud, right? So I've added those 3 additional rules to my Black letter review. Yeah. All right. If you can hang out, if you want to hang out, if you have questions, I'm chilling with you. If you've got a class, I need you to go to class because I need you to be to class on time, right? So I'm going to stop the share and I'm just going to hang out here for a few minutes. If anybody wants to chat, if you've got any questions, if you want to review something, I'm here. If you've got to go, not a problem. Go, do not be late to class, right? Because we can always talk about this stuff later. Okay. All right. For anybody who wants to hang around, did you guys have questions? Did I just screw up your thoughts about something? Did I confuse you about something? Right. And Mr. Thompson, were you waving goodbye or did you have a question?
Yes, ma'am. I have a question.
Please.
You guys said earlier, I'm trying to find my notes, you were giving a list of the purposes of annulments in comparison to probably something else. I was wondering if you could say those. A divorce, yes. Can you say those purposes again?
Right. So the purpose of an annulment is to, 1, return the grudged party to the status before the bad marriage, right? So if I want to be able to hold myself, if my status is I've never been married, an annulment will allow me to do that, right? Because the annulment wipes away the existence ever of that marriage, right? I may want to file an annulment because I'm a putative spouse, right? And I want property, or I want, if we had children from that relationship, I want child support, right? I want some type of property or settlement arrangement. Or like in the Seja case, well, in the Seja case, she didn't file for annulment. She wanted to be a putative spouse so that she could bring wrongful death. So the annulment gives me some latitude to wipe this bad, voidable marriage out of I can act like it never happened, but it can also protect me if there's children or property issues that need to be resolved, because now I have a court order. Does that make sense?
Okay, I guess where I need clarification is how it protects them, like you were saying with property and child support. I think I'm missing that point.
An annulment is a court order. A court order. It's a piece of paper that a judge signs that says the marriage that you had to Mr. Thompson is void, it's invalid, right? So we're going to invalidate it. Oh, wait, y'all had some kids? Well, let me also put in here some orders regarding those children. Oh, wait. Y'all were together that long? Y'all actually have property? Oh, okay. Well, let me also put in this order, some orders about who's going to get this property, because you were the innocent spouse and you shouldn't walk away from this with nothing, even though I've just relegated your marriage to nothing, right? If I don't file an annulment, I don't have a court order. I don't have a judge's signature on anything, right? Because remember, in my void marriages, where it's incest or whether it's a multiple marriage, it's void on its face, right? I don't have to do anything, right? I don't need a court order to say that my marriage was invalid. It's invalid because it's invalid. So I don't have to do anything. But if there were some kids, then I'm going to have to go to child support court, or I'm going to have to file a SAPSA, or I'm going to have to file something, right? Or if we had property, then I'm getting ready to take you to small claims court, or right. I'm going to have to do something, but I don't have to file an annulment. Does that make sense?
Yes, it is. Thank you.
Right. So the annulment takes care of all of it in one fell swoop, right? Let's just go ahead and let's make it right. Let's make all of it right. That's what I was trying to communicate.
Thank you.
And no, thank you for clarifying it, because if it was confusing to you, somebody else probably missed it. But anybody else? I see you, Miss Murray, Miss McMillan, Miss Gilmore. Mr. Thompson, did you have anything else?
No, ma'am, that's it. Thank you. I'll see you Wednesday.
Yeah, no problem. Miss Murray, Miss Gilmore, Miss McMillan, anything?
I don't have a question about the material. I was just wondering if you will be in your office today.
Not today. I will
Okay.
be back on Wednesday. But do you
Okay.
need to meet with me?
No, I'll just stop by on Wednesday.
Sure.
Yes, ma'am.
Okay, all right, because it doesn't have to wait. I mean, we can kick Miss Gilmore, Miss McMillan off, and I can work off, and we can chat.
Oh, no. I'll just stop by on Wednesday.
Okay, come see me Wednesday.
Okay.
You can walk me back from class if you like.
Okay, perfect. Thank you.
All right, Miss McMillan,
All right,
Miss
bye-bye.
Gilmore.
I'm sorry. I had a question because I understand the putative spouse and the bigamy and polygamy.
Yep.
I just don't want to get confused when I'm dealing with an essay, because as I see polygamy and bigamy, I automatically go to putative spouse for some reason.
As you should.
I don't know.
You should.
But I'm just trying to, I guess, because like you said, look at the facts and I guess see where they kind of lead you and then do your analysis. But with them being so similar, would you even discuss either one in the context of one? So if I have facts talking about polygamy and for some reasons a fact stands out that triggers putative spouse, should I just go ahead and talk about that? You're muted.
Great question. Can you hear me? Okay. I changed my microphone because I was hearing some feedback. Great question. What is going to lead you? Let the call of the question lead you, right? So you get a fact scenario, you get a hypothetical situation, and you read through it just to kind of get your bearings. That's that first read. That's that quick read, right? You're saying, oh, common law marriage. Oh, I'm saying putative spouse. I'm saying annulment. That, oh, she filled this one with some good stuff. There's going to be an ultimate question, right? Is the marriage between A and C valid? Does A and C have a common law marriage? Is C the putative spouse of A, right? There's going to be an ultimate question.
Mm-hmm.
Let that question guide your analysis.
Okay.
Right? So let that question guide you on the second read as to how you start to prioritize what facts are important. Yeah.
Okay.
So just because, and it's your mind should start to automatically go to these different places because you know these different doctrines touch different things. So that's a good thing. Don't stop that, right? Encourage that. But you don't get on the highway to go to any direction until you know what the destination is. And you're not going to know that until you find the question. Mm-hmm. Right. And so read it through, get to the question, and then let the question be the anchor by how you answer all the rest of it. Right. Okay. Because the question might be a common law question, not a putative spouse question at all. Right. But you realize that there is a putative spouse. If it's a common law question, your answer is going to be framed around the anchor, which is common law. You might not even address putative spouse at all. Okay. Does that make sense? Right. Because yes. Understand that they're putting stuff in there to distract you. They do that intentionally. Right. It's like, are they going to follow this rabbit hole, or are they going to get lost and miss the dispositive issue? Yeah. Okay. So be on alert. It's my daughter plays volleyball, and it you know, it's like you stand on your toes, right? It's like you stand ready. You're ready to go in whatever direction you need to go in, right? So be ready, right? But take off in the direction of where the ball comes. Take off in the direction of the question.
Okay,
Does that make sense?
yes.
Okay, all right. And if it doesn't, I mean, we can talk about it, but that's how you're going to read those essays. I'm gonna do a quick read. I'm gonna see some highlights so that I'm already pulling those folders. I'm pulling the folder for putative spouse. I'm pulling the folder for common law. I see you. I'm gonna pull these folders. When I get to the question, I'm gonna be like, oh, okay, this is the only folder that I really need.
Okay,
Yeah.
yes.
All right. Amazingly done. Thank you.
All right. Thank you. You have a good day.
I'll see you Wednesday. I cannot wait, girl. We're gonna have chocolate or something.
Okay,
See you Wednesday.
okay.
Thank
Bye.
you.